So judging just by face alone, I really like Jones. Okay, out of the Kentucky Court of Appeals, you got 14. So Supreme Court, you got 7. Supreme Court justices. When it comes to the Court of Appeals, you got 14. And these are all elected positions. So at one time or another, all Kentuckians voted these folks in. In order to be a judge, you have to be a lawyer. So that's a requirement. You have to go to law school. And in fact, there seems to be there's a lot of corruption. There's all these folks make about $130,000 per year, and they're $1 million positions. So it's not a surprise that there be corruption when you get into such high levels of money. Ultimately, all you want in a judge is one that judges fairly, is impartial, looks and listens to both parties, and tries to come up with the best solution for those two. Even though our court system is designed to be competitive, I believe truth and justice should come into the process at some point. So yeah, it should be competitive, and the prosecution and judge wants to get a lot of people behind bars so they can brag about how fucking awesome they are. But honestly, that's not the point. The point isn't to throw everybody in fucking prison. The point is to make society a better place. Okay, so just throwing the hammer at somebody that's should be the last resort. All peaceful options should be exhausted before we go directly with that. And yeah, so I don't know any of these folks, so they could very well all be very good and honest folks, and maybe it's just the Supreme Court, which is the corrupt court, So yeah, there's 14 folks. Kentucky Court of Appeals. Acree, Nickel, Dixon, Taylor, Mays, Lambert, Caperton, Thompson, Clayton, Van Meter, Jones, which I like Jones by just face alone. Just if I was just to base my judgment on a person based on face, she seems like a person I can relate to, working class. You can tell she's had a hard time, but still smiling through it all. So good for her. More, and then Stumbo. I'm not sure. Stumbos are all over the place. I heard some of them actually got arrested, I think, in Eastern Kentucky. But you also got Greg Stumbo, which is the Democrat leader of the House or Senate, and then Combs. So that's the Kentucky Court of Appeals. I'm going to get to objections and reasons to appeal coming up. Objection, Your Honor. Leading the witness, right? So it'd be like, did you or did you not, kill Mr. Hansen? And I don't know why. I don't want to pick on the Hansen. So, did you or did you not kill John Doe? Okay. No. Well, you didn't really like him though, did you? No, I didn't really care for his opinions about policy. Aha! So it's possible you may have a motive. I didn't kill John Doe. Duh, that's not what I asked. I asked if you had a motive. Well, I suppose I had a motive. No further questions, Your Honor. Any expression of feeling or disapproval or opposition? Objection! Your Honor, objection. List of objections in law. Reasons to appeal. This is going to be a big thing too. Okay, so why can you appeal something? Of course, on a technicality that you didn't have due process, the judge didn't let you have a public defender. That's grounds for an appeal. Some part of your due process or rights were not upheld, so that would all be under the appeals process. The Kentucky Court of Appeals is the lower of Kentucky's two appellate courts under Kentucky Supreme Court. Prior to 1975 amendment to the Kentucky Constitution, the Kentucky Court of Appeals was the only appellate court in Kentucky, meaning a court that you can appeal to. So you can appeal to the Court of Appeals or to the Supreme Court. You first got to go to them and then to the Supreme Court. So both of these you can appeal. So you can appeal your district or circuit court trial to the Court of Appeals and then appeal that to the Supreme Court. The Court of Appeals has 14 members. 2 members are elected from each of the 7 districts, serve 8-year terms of office, right? $130,000 positions times 8, over $1 million positions. And then they're judged, so they got all that power, and they can judge on day-to-day type of activities. The Kentucky Court of Appeals judges are elected from districts that mirror the 7 districts, which elect the 7 justices of the Supreme Court of Kentucky. The 14 judges select 1 colleague to serve as chief judge for a 4-year term. The chief judge assigns judges and cases to panels. The current chief judge is Glenn E. Acree. The Kentucky Court of Appeals usually sits in 3-judge panels. Membership of the panels rotates so that all judges sit on at least 1 panel with each of their colleagues in any given year. Usually 1 judge is chosen to author the majority opinion for each panel in a particular case. The Kentucky Court of Appeals has a headquarters building and courtroom in Frankfort, the state capital. But unlike the Kentucky Supreme Court, the 3-judge panels of the Kentucky Court of Appeals frequently hear cases in courthouses all over Kentucky. So they're like mobile, right? 3-judge panels are mobile. They go all over Kentucky for the Court of Appeals, the 14 members. Kentucky Court of Appeals hears appeals from Kentucky circuit courts with exception of criminal cases involving sentences of death, life imprisonment, or imprisonment of 20 years or more that are taken directly to the Kentucky Supreme Court. So the circuit courts get bumped up to the Court of Appeals, and I guess the district courts get bumped up to the circuit court, and then the circuit court goes on up to appeals, and I guess that's the process. I don't know if you could actually skip circuit court if you're a district court or not, but definitely Court of Appeals and Supreme Court you could appeal to, and that would be the only way you could do it from the circuit court, or a family court, which I don't know what jurisdiction the family court even has. It almost seems like it's a rogue isolation. It can do its own thing, right? It doesn't even need to listen to due process or to provide any of the safeguards for defendants. It's supposed to be private, so that way the family matter is private, but at the same time, if you're not implementing justice and paying attention to what is right and wrong, then you could get some really bad fucking, instead of protecting the victims, you could be protecting the perpetrators and putting a tag on the victims and just furthering the abuse instead of actually, rectifying the situation. The Kentucky Court of Appeals has a headquarter building and courtroom in Frankfort, the state capital, but unlike the Kentucky Supreme Court, the 3-judge panels, right, I already said that. So 1976 law mandates nonpartisan judicial elections. There's been some debate about nonpartisan. It means that you don't run on a Republican or Democratic ticket, but it doesn't prevent you from using free speech. In elections, you're allowed to use free speech. So it's a nonpartisan election, but you can tell people that you're Republican or Democrat. I think so. I believe that's true because it's, the truth of the matter, right? It's that's true. If you understand that they're a Democrat, you might be able to understand how they were ruled in certain cases versus, how a person who identified themselves as a Republican would rule. This is an interesting sort of Kentucky history tidbit. There's a change of court. So the executive branch dissolved the Supreme Court and erected a new one, and so they actually had 2 Supreme Courts, or 2 court of last resorts in the state. And so some people recognize in one and some recognize the other. So you essentially had 2 governments. You had not just a divided government within itself, but it was 2 separate governments. So the only time that I know we had 2 separate governments was in the Civil War, when in Bowling Green the Confederates, once they got kicked out of Frankfort, went to Bowling Green and established, the Confederacy there. So you had the Union, Frankfort capital government, then you had a Confederate government, just like here. Old court, new court controversy is a 19th century political controversy in Kentucky, which Kentucky General Assembly abolished the Kentucky Court of Appeals and replaced it with a new court. So the legislature dissolved the Supreme Court, and I think they're allowed to do that constitutionally. They replaced it with another court. The justices of the old court refused to recognize the action as valid, and for a time 2 separate courts operated as the court of last resort for Kentucky. The controversy began when the financial panic of 1819 left many Kentuckians. We had the big, the Great Recession was at 2008, 2009. It left many Kentuckians in debt, unable to meet their financial obligations. A debt relief movement began in the state. Pro-relief candidates won majorities in the General Assembly in 1820. The Assembly passed a law of replevin that was extremely favorable to debtors. Disgruntled creditors challenged the constitutionality of the law, appealing the case to the Court of Appeals. The court opined in favor of the creditors. Attempts to remove the anti-relief justices failed. The pro-relief legislature passed a measure abolishing the Court of Appeals and replaced it with a new court, to which pro-relief Governor Joseph Dasha appointed pro-relief justices who upheld the Replevin law. As the economic situation in the state improved in the second half of the 1820s, the old court supporters regained control of both houses of the General Assembly. They abolished the new court and restored the old court to power. In a 1829 case, the court nullified decisions rendered by the new court. In 1935 case, the court struck all the new court cases from Kentucky common law. So the new court failed, which sucks, because I'm totally with the debtors on this fucking side. The bankers fucking won this battle. The bankers was able to keep the old court, and all the laws that the new court was able to fucking pass was abolished. Even though they were talking about the constitutionality, so we're talking about a different constitution, actually. This is Kentucky's second constitution. Joseph Dasha is actually, he's a big ass fucking Confederate. I think he was, he gave birth or was responsible for chasing the biggest slave uprising in Kentucky. I think Patrick O'Doyle, or some Irish man named Patrick, led a slave uprising, and the Dashas were the ones that chased him down and hung, 3 of the black folks, and threw Patrick into prison for 20 years, but most of them actually escaped. So the biggest massive slave uprising and runaway, I guess, was that happened in Kentucky, had the Dashas on the wrong side of history, but it had Patrick on the right side of history. So I'm not even going to talk about this guy. That's we're talking about basically just Kentucky civics, right? So all things legal having to do with Kentucky. That's what all this covers. So objection, ambiguous. Objection, confusing. Objection, misleading. Objection, argumentative. The question makes an argument rather than asking a question. Asked and answered. Objection, asked and answered. Objection, badgering. Objection, best evidence. Objection, beyond the scope. Objection, calls for conclusion. Objection, calls for speculation. Objection, compound question. Objection, hearsay. Objection, incompetent. Objection, inflammatory. Objection, leading question. Objection, narrative. Objection, privilege. Objection, irrelevant or immaterial. Objection, lack of foundation. Objection, fruit of the poisonous tree. Objection, best evidence, rule, or hearsay. You can get subpoenas when you become a defendant in a case. You actually are afforded an entire host of rights. The 7th Amendment to the United States Constitution says that any matters that involve a fine of $20 or more, you're guaranteed a jury trial. So seatbelt tickets on up, because that's a $25 fine plus $100 fucking in court costs if they try to be dicks, right? That's $100 something in court fines, and then $25 is the fine itself, so that's over $20, meaning you're guaranteed a jury trial. They don't want to fuck with jury trial. Costs $20,000 to get a whole jury trial. So if it's something small and petty, they might just say fuck it and not give a shit, or they might just call the jury in and try to get it done real quick. But usually, the prosecutor, the judge, they're against you. They're with the police. They're with the people that are pushing, pressing charges. A lot of times they're friends with them. They know each other behind the scenes. Who they're friends with is very fucking important with how they're going to judge. Of course, they're going to side with friends and try to go after enemies, pretend they're, under the guise of law. The subpoena dulcis tecum. This is actually in both the American Constitution and the Kentucky Constitution. You could subpoena. So Section 11, the rights of the accused in a criminal prosecution, change of venue. In all criminal prosecutions, the accused has the right to be heard by himself and counsel, to demand the nature and cause of the accusation against him, to meet witnesses face to face, and to have compulsory process for obtaining witnesses in his favor. So I have a compulsory process for obtaining witnesses in my favor if I'm the defendant. So since I am the defendant, I can subpoena people, which is the compulsory process to get people to testify or to bring evidence into the trial. So if I had a case where I want to get my files, if they had a file, say like at the corporation where I worked, then I could issue a subpoena and put it on the CEO, and then have him bring the file that they have on me to the court. Open Records Act, you got a file on me, I believe I have a right to know about it. I can also use a subpoena to bring witnesses. So if there's people that I believe not necessarily are my friends, but would be beneficial to my case, because people could see that they're lunatics, right? That they're crazy or that they're no good. You could subpoena them and put them on the stand, and then once you subpoena them, then you can ask them the questions and either get what you wanted or not. You don't have to really just ask the questions, right? So if they're truthful and honest, they have no problems. Compulsory process for obtaining witnesses is my favorite. For any defendant, it's me or any defendant, anybody that's charged with a crime, he cannot be compelled to give evidence against himself, right? The Fifth Amendment, nor can he be deprived of his life, liberty, or property unless by the judgment of his peers or the law of the land. So until there's a jury trial, I cannot be deprived of life or liberty. The jury trial or the fucking bench trial is what will determine whether or not I will be free. So, he shall have a speedy public trial by an impartial jury of the vicinage. So I guess the vicinity, so of the people around it, an impartial jury, right? So there's a jury trial, not a bench trial, but a group of your own citizens. The General Assembly may provide by a general law for a change of venue in such prosecutions for both the defendant and the Commonwealth, a change to which to be made to be the most convenient county in which a fair trial can be obtained. So the most convenient county, if you think that the people would be, biased against you, then you can ask for a change of venue so you can actually get a fair trial. So that's all that. All those are rights that are afforded those who are accused, and that's important because unless you have due process, you cannot sit there and point at somebody and say they're guilty of something unless they agree to it, unless they confess or pay the fine or call themselves guilty. You should also never call yourself guilty. In Kentucky, you're allowed to plead an Alford plea. You're allowed to plead no contest. And you should be allowed to plead no contest because that's essentially saying, it's a guilty sort of plea, but it's not guilty. It's saying that there's enough evidence to convict me, but I'm not saying I'm guilty. I'm saying I'm not contesting it. I'm not contesting the charges. So typically it's taken as a guilty plea, and then once you give no contest, then you're given the punishment or fines of that charge. So it operates as a guilty plea, but you're not admitting any type of guilt whatsoever. You're saying you just don't contest the charges because of the evidence. It's not so much that you think you're guilty or not guilty. It's just that you think there's enough evidence in the bush or in the basket to convict you. So, right of a judicial remedy for injury, a speedy trial. All courts shall be open, and every person for an injury done him in his lands, goods, person, or reputation shall have remedy by due course of law, and right and justice administered without sale, denial, or delay. So, right of judicial remedy for injury, speedy trial. So everybody is guaranteed a speedy trial, right? So I have a legal right by Kentucky Constitution, American Constitution, to subpoena witnesses, to subpoena evidence. And so if there is evidence or witnesses that I want to curry in my favor and I'm the defendant, then I have a right to fill out this form right here, the subpoena dulcis tecum form, right? Case number, right? Go ahead, the 66774, court, county, date, plaintiff, defendant, and you could type all this in, right? So this is all the files are online. It's actually really good about Kentucky is even though there's no foundation for any of the laws, it's all available online. So you got KRS up the ass, from 0.001 to 999, million. So the executive branch, I just found this out, and then I'm going to end it off with this. With the police, I used to think the police were kind of in no man's land. I didn't know where the police existed with the three branches of government. There's other branches in other countries. There's an election branch, and then there's media branches in some of the Latin American countries. So there's actually like 4 or 5 branches of government. But none of those, media or election would cover the police. Maybe the election a little bit, but the executive is the ones who control the police. So when people say that the sheriff is the court of last resort, or sort of the last man that would determine feds can come in or not. Really, it's the judge executive. The judge executive controls the police, especially the county police, and the budget for the sheriff's office. So they don't directly I don't know. Actually, I think they do directly can give the sheriff orders, and the judge executive, their orders have to be listened to, especially if it's policy. You know, you can't be ordered to do something illegal, but any lawful order, they're the executive branch. They're the ones that enforces the rules. So I used to think it was part of the judicial branch. The police were part of the judicial branch. That's not the case at all. The police are part of the executive branch. So when it comes to sheriffs arresting judge executives, they can do that. The judge executive can also arrest the sheriff. Everybody's got the right to a citizen's arrest, but as the executive branch, that's the face of the government. So that's the government itself. For a sheriff to be able to arrest a judge executive is remarkable, and it's great. And for a person who fights for the working class values, I love to see powerful and the rich, corrupt people go down. Even just for the images, right? Just for the images, even if it all pans out that it was one big misunderstanding, it's a great theater, it's a great show. And people would love a person like that, a trust buster, busting monopolies and going after, corrupt fucking corporations that just price gouging the fuck out of people, like the oil companies. In Kentucky, we're in Somerset, they got the gas station right now. The government is investing in gas stations to compete with all these other gas stations because they just keep gouging all the tourists, and they didn't like how they were doing that. So the police, I thought, was in no man's land in between judicial and the executive, and they are, because the police are the beginning of the criminal justice system. But the criminal justice system is, a windy road through the process, through the judicial process. So you got the prosecutors, you got the police, and you have judges. No. So you got the prosecutors and you got the police, who are on the executive branch. They're part of the executive branch. So the governor of Kentucky, the mayors, the judge executives, these are all executive positions, and what they say goes. So they're the chief of police. They're above the police. So, the one can arrest the other one can arrest the other one if they know about a crime. Now, there's another case actually that happened in Gallatin County, where you had one police officer arrest another one. He was drunk and passed out on his own lawn, and he arrested him when he was drunk and said he was guilty of a DUI. It was the chief of police. And so that just essentially told me, when one guy can get the other guy in handcuffs, that's when you can arrest somebody. So when that thing went down in Jackson County, where the sheriff arrested the judge executive, the sheriff looked to the county attorney, and the county attorney, his interpretation of the law was the sheriff could fucking arrest him, and that's what he did. But it didn't have to go down like that. Very well, the judge executive could have arrested the sheriff. So I don't know why the judge executive doesn't do something like that. He has the sole authority and responsibility for the daily administration of the state. That's the fucking governor. It's the fucking mayor. It's the fucking judge executive. That's the state. That's the county. That's the city. That's the face of it all. And they're the ones that, balance the budget. They're the ones that signs new laws into order. And when they sign new laws, they're the ones that are going to be the ones, to enforce the rules that they pass. And so they have to have a mechanism to where they have to get to the police. So when the executive signs a new law that the legislators put out there, it's up to the executive to tell the police and the prosecutors that this is the new law and this is how things are run. Separation of power system is designed to distribute authority among several branches and attempt to preserve individual liberty in response to tyrannical leadership throughout history. The executive officer is not supposed to make laws, the role of the legislator, or interpret them, the role of the judiciary. So the judges interpret the law, the executive enforces the law, the legislator makes the laws. So the judiciary is the one who interprets the law. So if there's a case that is brought before the judge, they'll determine how that case applies to the current law that's at hand. And that's their job. That's what they're supposed to do. But I don't know. It seems like a lot of times the judicial branch is actually more powerful, and they're the ones running the day-to-day operations of the system. But the executive branch is the one that controls the police. They're above the police. I saw this, criminal justice in the USA. So, which of the following in the Bill of Rights is a police officer least likely? No. Which branch of government of the U.S., which branch of the U.S. government do police officers fall under? The legislative branch makes the laws, the judicial branch interprets the laws, and the executive branch enforces the laws. Although you may have been tempted to say judicial, that branch only deals with the courts. So there it is. The executive branch is the branch that controls the the police. So let's see. There's other systems. There's governor and mayor. We're gonna look up governor and mayor because they're the ones that control the police. So we learned about subpoenas. We learned a few of the objections. Right? Objection, Your Honor. Hearsay. Objection, Your Honor. You're leading the witness. Objection, Your Honor. I'm badgering you. I mean, call for a conclusion. What? So Major Payne. It was a funny movie. I enjoyed it. It was a good time. Here you have federal courts. So the federal courts and the state courts, like, what's up? What's going on here? I think the federal. I don't know any Kentucky people that actually listen to Kentucky law. Seems like the ruling class and just a clique, they kind of interpret shit the way they want to interpret. Who knows if they're actually doing it in the way they're supposed to be doing it or not. This is taking forever, so I'm just gonna. Sayonara. Okay. The highest ranking officer in a municipal government is the mayor. Many municipal systems, the mayor serves as chief executive officer and or ceremonial official of many types of municipalities. Worldwide, there's a wide variance in local laws and customs regarding the powers and responsibility of mayor as well. Being mayor, I would like to know blah, blah, blah. So we learned nothing. Nothing was gained. Nothing was learned. Subpoena dulcis tecum, also known as subpoena for production of evidence. To court summons, ordering the recipient to appear before the court, produce documents or other tangible evidence, such as witness testimony for use at a hearing or trial. The summons is known by various names in different jurisdictions. Alright. So that's subpoenas and Kentucky Civics 101. Number 7, I believe, is done.